Okay, this just in. These are essentially the reasons somebody might not take on as a disabled claimant for representation in 2024 as a law firm that usually helps people get disability benefits. Now, there's a lot of things that you need to know about this. Please remember to like and subscribe to the channel if you want to see more videos. It just helps us basically future fund more, gear to be able to do these videos. But here's the bottom line. We're going to be going through essentially all of the reasons that you might have not been able to find a law firm to represent you for disability benefits, which is becoming an ever more frustrating problem for people seeking getting representation in front of the SSA, because let's just be honest about it, the SSA is becoming more and more and more difficult to go ahead and obtain disability benefits from. And when President Biden was brought in, I think a lot of people thought that a lot of the commissioners saw under President Trump's rule changes, like the evidence rule change for appeals counsel. That one just makes me bitter. But a lot of the rule changes we thought would be, many of them would be rolled back. The one major one that was rolled back was basically the 2-year CDR provision, which is for the most part useless because you could still have a CDR every 1 or 3 years. But the point is, we thought with this different president on the liberal left side that they were going to roll back a lot of the stuff that Commissioner Saul did. Almost all of it has remained in place. And it's harder to be found disabled now. And the process is way more miserable. So let's go through this real quick. Please remember that in the beginning with this whole thing, in being the most viewed and subscribed to Disability Attorney in America, I can de facto say that if you subscribe, the YouTube money does help me go ahead and work with the homeless. And here's why. We still represent some SSI people, some Supplemental Security Income people. Most law firms will not touch them. They won't touch them. And the reason why is that when you have a staff or group of people working on that claim, usually ultimately what you get paid is not how much it actually cost to fight and win that claim. Like the cost of the staff cost more than what you were able to win from that SSI claim. So these videos do help me continue to, especially on Wednesdays when I go to the homeless center, continue to work with the homeless. So please remember to subscribe. Please remember to go ahead and click that like button. Now, here's the deal. So of these categories that I'm about to present to you, you will hear some that we still as a law firm represent. But I know as an industry, like categorically as an industry, many disability law firms are no longer representing these types of individuals. It's almost a full cutoff in 2024. And I was telling you about this way back in, basically 2014, 2015 about what was going to happen, even going back to 2013. But the point is, 2014, 2015, I started really going into like what's going to be the change. And everybody said I was wrong. It was fear mongering. And now it's completely true. Everybody knows what's happening. And now I'm the good guy. But back in the day, I was the bad guy. But that's okay. That's okay. I'll live with that. Please remember to like and subscribe. But first off, understand that these disability law firms, when they won't represent these disabled claimants, even though some of them are clearly disabled, it's a business that has employees. And the employees are the largest cost. It's not the rent. It's not the building. It's not the utilities. It's the employees. If we take claims that do not pay, it means we spent thousands on something that we get no money in return on. This equates to a literal out of business immediately situation. It's a bankruptcy situation. Disability law firms do not bank well like VA attorneys or PI attorneys, veteran affairs attorneys for disability benefits, or personal injury attorneys. And there's other fields as well. Disability law, SSDI law, SSI law is a niche field. And we are seeing a consolidation among those firms, people getting bought out all the time, left and right as a result of it. In fact, one of the largest Social Security disability firm was purchased by a VA firm, which then changed its name to a totally different group. Okay. Now, with that said, I'm going to go through the categories right now. I hope you're ready. Number one, that disability law firms just aren't representing anymore going into 2024. Overpayment claims. Now, I'm going to do a video on how to beat overpayment claims. I just haven't finished it yet, but I will be doing that video on it, and it's very detailed. And the reason I'm doing that is because I'm going to show you step by step how to work the overpayment claim in an attempt to beat it. But what you need to understand is that I'm doing this because literally we don't do them anymore. I think pretty much every law firm out there no longer does those types of claims. Okay. So if you have an overpayment where the SSA overpaid you, you received funds that you weren't supposed to, or you were working or doing something wrong, and then they said you had too much for those months, pretty much no disability law firms are going to be doing those throughout 2024. Number two, claimants who have had a prior attorney who did not withdraw for fees but only for representation. So when an attorney withdraws from a claim, right, there's two things: fees and representation. Most of them will withdraw for fees, but not representation unless they truly did something wrong. And so as a result of that, most law firms will de facto not take your claim to take it and fix it and work it and win it if you have a prior attorney that did not withdraw for fees. In fact, one of the biggest law firms, it's actually the biggest law firm out there, right? They advertise that, used to make a lot of money off of my firm because we would get claimants from them and then we would go ahead and work the claim and win it. And then they would get a percentage of it. We no longer do that. We do not take claimants who cannot get rid of the prior law firm. That's just the bottom line. Next one, number 3, bubble claimants. Okay. Bubble claimants are those who live essentially in a bubble. They have parents that will go ahead and provide them with a room or food or whatever, or grandparents that'll take care of them. They provide them with all the stuff they need. They live in a bubble. And those bubble claimants, they never truly get a lot of medical treatment because they live in a bubble. They don't have to get out of their bubble. Their impairments never really get that bad because they're not forced with the stress of knowing where their next meal is going to come from, where they're going to live when they don't have anything, etc. So as a result of that, what's happening is these bubble claimants, right, that are protected by their parents or protected by their grandparents or whatever accommodation or creation it is, those claimants are completely out for the most part in 2024. And here's why. They are just not good claims. You can't get them to go to medical. They often don't take the medication as they're prescribed. They're often egotistical, the whole lot of it. Okay, next one, number 4, people under 50. Very, I mean, you still have the kid claims, which is a different category. Basically, you're looking at 18 to 49 a day before 50, 19 a day before 49, or a day before 50, or 22, because there's these little gap rules if they're still in school. But the point is, people under 50. Getting grid outs, it adds an entirely additional option to getting somebody found disabled. Compassion allowance listings, grid outs, and vocational allowances. If you take away the grid outs, then you've just taken away one of your main arms of getting somebody found disabled, which is very easy compared to an individual that's under essentially 50 years old. So claimants that are under 50 are almost going to be a complete cutoff going into 2024. SSI people in general. Most of these claims we lose money on. It is what it is. And only a few do we even break even on at this point. The SSI claimants are tough to represent. Number one, they need help with their forms. So you got to spend a hell of a lot of extra time helping them fill out forms. You lose way too much money there. Number two, it's basic stuff too. It's like, okay, now move your pen to here. Now fill in your name there. Now move your pen to here. And a lot of you guys think that's ridiculous or it's impossible. There's no way. But you also probably don't work with the homeless on a weekly basis. So you might not have a real understanding as to how limited a lot of people are who are essentially homeless. And, a lot of people get aggressive towards them, like, oh, they're lazy. How could they do that? Many of them are not lazy. They just have mental impairments. Some of them are. There's no doubt about it. It just is what it is. But a lot of them, they can't read and write. If you're ever wondering what happened to that person that you're in school with who didn't make it past 6th grade and what happened to their life? Likely homeless, because when you can't read or write and do these functions because of mental limitation, maybe it's a low intellectual quotient, you better guess it, they can't get a standardized job and they have a hard time keeping it. Okay. So basically, SSI people, supplemental security income, a lot of law firms are not going to be touching those claims going into 2024. They cost too much money to work on them, and then you get paid far too little. So the basic thing is most disability law firms, they're shooting for $7,200. $7,200 just doesn't cover grocery costs, whether it's home grocery costs or business grocery costs. Because, when you go to, like I said in the prior video, you have going to the grocery store and getting food, right? Or clothing. And then you have going to the business grocery store and getting computers, printers, cameras, pens, pencils, paper, whatever. Yeah, this stuff is just as, if not more expensive than the actual stuff you buy at Walmart. So what a lot of people don't realize is that the economy isn't just bad in a personal sense to you on a personal, hey, I don't like going to the grocery store now because my check goes to that. Businesses have the same problem. All the stuff that they have to go ahead and buy to do what they do, massively, massively more expensive. You're looking at anywhere from 25 to 65% increase just over the past couple of years. So horrible economy situation for corporations. Okay. Next one, number 6, non-active claimants. Non-active claimants. Okay. So basically, claimants who essentially are super non-active, you call out to them and they don't pick up the phone. You text them, they don't text you back. You email them, they don't email you back. And then you get this is the classic thing. I'll get a call or a text 3 days before the hearing. Like, hey, I haven't been well. I haven't been, and it's like, for 6 months they weren't well, but they couldn't just text me back, give me a call. Those types of individuals, law firms are going to steer clear of them. If they're not able to communicate with the person, because look, it's harder to get somebody found disabled now. So it's like, having like that situation where a person is just not willing to cooperate, to participate in the process. No, it's too much of a problem, and it screws up the docket calendar. Like, a lot of you guys don't realize, but there's this calendar that we disability attorneys have. So like, if you have this docket calendar where essentially, it's one of those, let's see, it's one of those things where, you're looking at it, and here are your hearings, here are the problems, little fires to put out, here are the things that you've got to work on, here are the forms you've got to update, here's the big meetings coming up. When you're like a problem, you end up on that docket calendar every couple of months, right? And then we have to deal with it and deal with it and deal with it. Instead of, and remember, when we go to deal with it, it doesn't move forward. Like, if you don't contact us, interact with us, it doesn't move forward. So it's just this sitting there claim that's costing us time. We're not getting anywhere with it. We'd much rather fill it with somebody who actually wants to go ahead and build and do a better job with the claim. All right, excellent. Next one. All right, let's see what we got here. Okay, so next one over here, the claimants who always lose their phones. Super problematic. So this is an individual problem for people who are super poor, who are in poverty setting, who basically also tend to have those minute phones, those free phones. Their phones get stolen, or they lose them, or whatever, for whatever reason. What you have to understand too is they're also many times selling them, because what they'll do is they'll get a minute phone. They'll sell it to a drug dealer, or basically a drug runner. And then that drug dealer / runner will use their phone to go ahead and sell drugs, basically by using that burner phone. And so, one of those things that's really annoying is that, like, when every 3 months they get a new phone, and then every month later they have to get a new number, not something a lot of people are going to be interested going forward. Okay, next one. Okay, so the claimant that you ask about, like, hey, are you going to medical? A lot of people think that they are entitled to disability benefits, but don't have to go to the doctor. So that has died. That whole like theory of being able to make it through the system and just kind of like, I don't like doctors, I don't have to go to them, so I'm not going to go to them, but give me a disability check because I'm disabled. That world is over. You're going to have repetitive, continuous disability review. Otherwise, it appears when they review your claim, they actually have a computer system that reviews your claim, like a computer system that goes in and looks at your disability records. Otherwise, it looks like you're a faker. Like, if you haven't gone to a doctor to seek medical treatment over like a 1.5 to 2 year period, that doesn't look good. And a lot of these people, I get calls from on the weekly basis saying, hey, I'm getting a CDR. Didn't expect one to get this one so early. And I asked, first question out of my mouth is, cool. When was the last time you went to the doctor for your impairment? Oh, I don't like going to the doctor. Cool. When was the last time? It's about 2 years ago. And that's the direction we're rolling in. Okay. All right. Next one. The hostile upfront claimant. So sometimes we get claimants who think that in order to get an attorney, you have to be hostile towards them. That's not how we work. No. So when you start screaming at somebody right up front, I understand that some claimants have a mental impairment where they have hostility issues and they blow up. But usually the staff is trained, along with myself, to know when that's the situation, right? We'll have a pretty good idea if this person just is a volatile blow up person who is that disabled person with that. Some people just have this egotistical approach to it of like, you have to represent me because I spent my time to call you, and you have to therefore pick up the phone and represent me because I'm important. And when they do that stuff, when they go through that and they do that, participation situation where they're throwing it at you, like you have to deal with it, you have to take it, you have to go forward with it, etc. It's a problem. It's really, really genuinely a problem, because at the end of the day, just to be very clear with this whole thing, when somebody is hostile up front, it's not a good, intro to having a teammate, because when you have a teammate, you're trying to get two people. One person is disabled, one person knows the system, to work together to create a profile, right? All of their medical records, academia records, administrative records, penal records, vocational records, and make it look like something the SSA wants to find disabled. So the bottom line is, just to be fair, if you're hostile up front, that's not what people are looking for that teammate kind of situation. All right, next one. The criminal background with sexual abuse. So I've been doing this for a while through other law firms, and then 10 years through my own law firm. And the bottom line is this: when you have a criminal background of sexual abuse, right? Some sort of charges against basically some other individual, for whatever reason, whatever their age is. Judges do not like to approve those claims. Just as the bottom line. Just as the bottom line. It might be a female judge, maybe a male judge. They do not like to approve those claims. We've had an extremely difficult time getting claimants through with that. And so the bottom line is, most disability law firms have that same realization, so they stay away from those types of claims. Okay, next one. The person who won't fill out forms, and I mean, even just writing in their name, like, you get claimants who you'll send the forms to, they'll tell you they're going to fill them out, they'll tell you they're going to fill them out, and then you just never see them again. And maybe they have an eyesight issue where you can, talk to them and, okay, see that's where you do that, and that way, cool. But then some of them they fall off the vine. That's just the bottom line. It's just they disappear. And, you'll be like, hey, did you fill out the forms? And then they'll start yelling at you because they feel like you have put in an impossible, can't be done, level of requirement on them, and they didn't do it. So now they look bad and feel bad. So they do the kid thing where they go like, oh, I can't, oh, you just, oh, these, oh, I can't, oh my, they go through that process of emotionally shedding their insecurities and anger over the phone or in person to you. And it's those people who just can't, the super procrastinators that won't fill out forms or do anything with it, even though they know they have to do it, and then it just sits in the back of the head. Those ones, disability law firms are just not going to take. And I get that it could be a disabling condition, but the same situation, it's one of those where when I sit back and I look at this, I say to myself, okay, look, it's a business. We got to get these done. We have to win so many claims. So, you have to participate kind of gig. Next one, and Collins gang, I see you there. Just give me a call on Tuesdays or Thursdays. Is the best to call in. Otherwise, I'm in just tons and tons of hearings. All right, next one. Here we go. The person who is currently using and abusing narcotics. So disability law firms have gotten way smarter and better at figuring out which claimants are using and abusing narcotics. And the reason why is that it will just, before we even really get into asking about medical, we'll have a few questions that we understand, ask you essentially about your narcotic use. And even when you lie to us, we know the lie answer is directing us essentially to what's actually going on. So when it comes to, like classic examples would be like, okay, well, do you still own that car? Okay, that you were driving, okay, cool. When was the last time that you were able to work? Okay, and what happened with that job and how many days did it last? So we'll know like the questions to ask, because when it comes to people who are currently using narcotics, I get it. We have claimants that are users and abusers right now. You know what I mean? But the bottom line is most law firms are not going to want to take that claimant because it adds this layer that requires what's called the materiality clause, which is basically where an individual who's taking and using drugs may have, created a situation where their impairments are going from moderate to severe as a result of taking those drugs. Now, if you took the drugs out of the situation, would their impairments still be severe, or would they just be in a moderate or mild setting? And that's what makes it material, is that it can decide a claim or not based off of how severe it is and whether those drugs made it too severe, made your impairments even more severe. So a lot of firms, just 2024, they're not going to be utilizing those. Next one. So the next one is basically the person whose date last insured is too much of a risk. VA people fall into this all the time. They'll spend all this time trying to win their VA benefits. They'll never apply for their SSDI benefits, and then their date last insured will have run. And the only way to fix it is to get more earnings on the record, which sometimes will try to screw up or harm their VA benefits unless they get into a program to get some additional earnings to boost their date last insured. VA people fall into this all the time. It's one of those situations where they're now being more aware of it because YouTube is teaching them and telling them, hey, you got to do this, this, and this. So the bottom line is that is slowly changing, but a lot of people still fall for the trap of the date last insured problem. Next one. VA claimants who have inflated percentages with moderate medical evidence. So one of the big problems that I get is I'll get through basically a VA person who will have like, this condition, that condition, that condition, that condition. And then when that happens, I see Danny, ICURN. Thank you for the $5 donation. That's absolutely amazing. Very, very cool. Can Walter help South Florida? Drowning next hearing March. My husband and dad both died, and I'm officially lost. I see your N22 you who can no longer walk. Yeah, just give me a call tomorrow, Tuesday. Give me a call tomorrow, and then we'll go through the claim details and go through everything. So with that said, it looks like next hearing March. So coming up around the corner. Okay, so and that's another, I'll tell you that most law firms that have claimants where the hearing is like 2 weeks away, a month away, they don't want to take those claims where the claimant will have not had an attorney, because they don't have enough time to buy the medical records. Usually we look for claims that have a hearing within 2 to 3 months so that we have enough time to buy the medical records. But if it's like getting iffy where a medical facility doesn't want to play ball, it will usually request that an extension be put in place so that we get an additional 2 to 3 months to go ahead and make it happen, because we don't want to do a hearing and then be stuck with the decision based off of what we were able to pull off in basically 2 to 3 months. So that's one of those situations as well. Anyways, I will catch you guys at the next video. The next video is about the FAA's diversity push, but I just wanted to make one statement about what's going on with the Social Security Administration and, what's one of the big issues. So it was posed to me in a phone call that I had with a gentleman about disability. And he said, and he said to me, this is going to sound, his thought here on this, that like a conspiracy theory. And the conspiracy theory basically that he wanted to tell me was that he felt that the SSA was purposely not hiring enough individuals and not getting enough funding to go ahead and do this because, basically he felt that the SSA, if it would not have enough employees, it would greatly increase the amount of wait time for people to be found disabled. More people would die in that time period and therefore not get their disability benefits. More people, unless it's SSDI trying to claim back pay for once they apply, but that's a small amount. So basically more people will die during the longer wait period of disability benefits. And then essentially what will happen is more people will drop off and have to get a job in between the appeals because they don't have any money in between. Do I think that this is something that's affecting essentially the current Social Security Administration? Yeah, probably. Look, imagine this. We had a bunch of politicians sitting around a table, right? And the politicians were like, okay, so what are we going to do here? How do we slow down the ridiculous amount of spending, right? This immense, incredible spending for SSI benefits, for SSDI benefits. How do we slow it down so that, essentially more and more people are not being found disabled? Well, the easiest way to do it is to change the rules to make it harder to meet certain legal standards for severity, which they did in 2017. Also, basically, not have enough employees to process all this stuff and create a massive backlog that takes forever, right? Which they did. That was like 2019, 2020, 2021. And then from there, make it so that they can't get more employees because they don't have enough money and the unions are not happy and everything's just kind of in this like destroyed cluster situation. Yeah, I mean, look, these are all tactics that directly equate to harming the SSA and therefore reducing the amount of people who can obtain benefits. Absolutely. If we look at the numbers related to it, the amount of people that are applying for disability benefits is actually going down slightly. So there is a cooling effect going on at the highest levels of how this administration is being administered. Do I think that this was super planned out? Maybe, maybe not. Who knows? I mean, if you really wanted to wreck the SSA, like if you were to just really wanted to like actually wreck it, what you would do is you would keep funding of the SSA at a similar amount. You would massively increase the cost of business, right? You would go ahead and decrease the intro education level of those who are essentially getting hired, because if you have a lot more people with less education or a lesser intellectual quotient, then you're going to end up with essentially worse results for a very complex system. And those worse results are just going to slow everything down by people having to fix problem after problem after problem after problem. And so as a result of that, what it ultimately comes down to is a situation of how do you slow down the amount of processed claims to the point where people they got to go get a job or they end up on some other situation, which, to be fair, I mean, there are literally people who actually move out of this country to go to another country to just live on some savings that they have. I mean, it's gotten weird. It's gotten bad at this point. But anyways, I hope you're doing absolutely well. Lily Bell, is alcoholism or alcohol a narcotic? They don't usually look at it as strongly as like an actual, heavy Hollywood style narcotic, but bottom line, it can raise to that limit. It is included as one of the things in the material test for alcohol. We call it ADA rule, but basically alcohol drugs analysis. So yes, alcohol can be considered part of that. So if you have it in your records, severe alcohol abuse, then yes, absolutely can be part of that. Anyways, I will catch you guys a little bit later, and I will see you at the next video, which talks about the FAA's diversity push and basically how they're trying to hire severely intellectual and psychiatric disability-based claimants to handle aviation. Spicy. Anyways, I will catch you guys a little bit later, and I will see you in the next video in about 5 minutes. Don't forget to like. Don't forget to subscribe. Catch you a little bit later. Thanks so much. Bye-bye, everybody. Bye-bye.